case briefs, and so much more. LSData's got what you're looking for.
In a landmark 1984 case, the Supreme Court of Texas contemplated an important question related to consumer rights, concerning a seller's ability to repair or replace returned goods once a buyer has rightfully revoked acceptance. The case, Gappelberg v. Landrum, hinged on a faulty television which proved instrumental in reshaping this aspect of the state's commercial law. The genesis of the dispute was when Nathan Gappelberg, having purchased a defective television from Neely Landrum, requested not only a refund but also the return of his old set. The complications grew when Landrum, unable to offer the old set back as it was promised as a prize to another party, proposed a replacement instead. Gappelberg, refusing the solution, decided to take the matter to court. The case was first heard in both the trial court and court of appeals, who ruled in Landrum's favor. However, Gappelberg, not willing to let the matter rest, appealed the decision. The Supreme Court of Texas took a different view on the matter. They emphatically sided with Gappelberg, arguing that once a buyer has legitimately returned a product, the onus is not on the seller to attempt repairs or propose replacements. Instead, the buyer is entitled to a refund, a decision anchored in the provisions of the Uniform Commercial Code. In overturning rulings from the lower courts, the Supreme Court awarded Gappelberg damages and attorney's fees. The case was further remanded back to the trial court, with instructions to determine the precise amount Gappelberg should receive for his legal representation throughout the proceedings. The hearing thus made a robust statement about consumers' rights when their purchases do not meet their expectations.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.